Good afternoon, Your Honors. In continuation of the interviews for the position of Associate Justice of the Supreme Court this afternoon, may we present to you Presiding Justice Andres Reyes, Judge Reynaldo DAWAY, and Justice Noel G. Thank you, Your Honors. At this point, may we request the Presiding Justice to please stay while Judge Daway and Justice Tiham are requested to go back to the holding area. Thank you. Again, Your Honors, the first interview this afternoon presides over the Court of Appeals, the Honorable Andres Reyes, Jr. Justice.
Good afternoon, PJ Reyes.
Good afternoon po.
Yes, our record shows that we have interviewed you in the past, no, and where you gave a statement about yourself. Do you want to give an additional statement?
Maybe I just repeat that at present the presiding judge of the Court of Appeals. I'm a career member of the Judiciary, being before a former MTC judge and an RTC judge, then as a Associate Justice of the Court of Appeals. Prior to that, I was a prosecutor in the Office of the Tanod Bayan.
Okay.
That's all, ma'am.
So that's it. Okay. Honorable Maria Milagros Fernand Cayosa will start the interview.
Thank you, Justice Lagman. Good afternoon, Mr. Presiding Justice.
Good morning po.
Reyes, now we've actually interviewed you several times before, so I don't think I have too many questions, just a few questions. We laud your efforts towards zero backlog, and I've noticed that you have taken the use of technology towards improving the systems. And I understand that the raffle of cases in Cebu is now electronic. Is this the same in CDO, in Cagayan de Oro, and here in Manila?
Yes, ma'am. It is the same for Cagayan de Oro, but not for Manila, because the electronic raffle system is only a donation from our development partners, the USAID, ABA Rowley. So there is none yet for Manila, and so we're just waiting for them. We are assessing if the electronic raffle is a success in Cebu and Cagayan de Oro. So we have not really made an assessment if it's really successful. But so far, the feedback that I have received is that the justices are much into using it all the time.
What would be your gauge to determine if the electronic system is successful? What will help you determine how effective it is?
Well, it is not anymore subject to error. Then, of course, the raffle will already be recorded automatically. That means that the result can be recorded automatically. And, of course, any raffle is all right, but considering that it is done electronically, it could be more believable to the public if it does not touch human hands. So perhaps that is what the public would need, or as proposed, that the raffle is done electronically and nobody's hand would touch the balls, and it is done by machine, not by a human intervention.
In your years of experience in the judiciary, what to you has been the most challenging ethical dilemma, and how did you handle it?
The problem that the court had when the GSIS case came about we were really all affected by that. And what I did was just to pray and to pray that the court be spared from all the problem. And it's good that the Supreme Court decided on the case, and we just prayed a lot that from that day on we move forward and do our best to serve our God and our country. And I have done that since that time. I've devoted, I said that it's time that we really pay attention to ourselves and to our country and to the law.
Now, there have been talk about perception perhaps of fixing in the Court of Appeals, and this came to fore when they started talking about Ma'am Arlene. I know that issue was raised several months ago, but I would just like to find out what measures besides the electronic raffle has the Court of Appeals taken in order to address this perception, so that, as regards the issuance of temporary restraining order or any delay in the disposition of cases, that perception can be done away with.
Well, I always visit the stations, Cebu and Mindanao, and we always talk about this. We always talk about integrity and corruption. We always address those things, and we have our mini small meetings with the senior members and the junior members and the division chairmen, and we talk about this, how we can address all these problems.
How about here in Manila? Have you come up with concrete measures to ensure that, that there will be no perception of corruption in the Court of Appeals?
Yes, I've been telling them that we should really adhere to the Daang Matuwid. And from day one, when the President of the Philippines, President Aquino, assumed office, I told them that this is a new day for all of us, and let's try to emulate what are the progress of the President. And continuously, we have meetings on this. I talk to the junior members separately, and I talk to the senior members separately, as well to the chairman. I keep telling them that honesty is the best policy.
Has any investigation been done? Has there anyone been disciplined as regards this particular aspect?
In the last 4 years, I have not, because the administrative cases are really handled by the Supreme Court in a confidential manner, I really have not privy to who are investigated. But for the past 4 years, I have not heard or heard any news about any member of the Court of Appeals in any way being fined or reprimanded or admonished for anything regarding corruption.
Thank you, Mr. Presiding Justice. Now, with respect to standardizing application of doctrines, what steps has the Court of Appeals under your leadership taken in order to ensure that certain doctrines are uniformly applied, such that if cases of similar facts and issues are raised before the Court of Appeals, you can come up with uniform decisions? So there is a certain degree of predictability if similar cases are brought before the Court of Appeals.
Well, we started early last year upon direction of Justice Bersamin. In one case, we make it now mandatory that all cases of a similar nature involving the same parties are decided by one ponente. Because before it was not really mandatory but was permissive. So the justice could still hold on to their case, and they could come out with different decisions on one case. So now we have a mandatory consolidation of these cases. So in this case, if those are the parties, there will only be one decision in all the totality of their cases that they have filed regarding that issue.
How do you make the determination if the issues that are involved are of similar nature? Is there an office that makes that determination before it is assigned to a justice?
Usually, the court reporter or the clerk of court would try to determine if there's such a case similar, like the employer filed the case and then also the employee filed the case. Sometimes nobody knows that both filed a case, and they would come out with different decisions. So those are the things that this ruling now that we have is mandatory, that it must be consolidated.
Thank you. And what I gather then, it's you're referring to perhaps labor law cases where
Yes.
you encounter such difficulty sometimes in the application of certain laws and
Yes,
doctrines.
yes.
Now, for my final question, now as a former trial court judge and now the presiding justice of the Court of Appeals, Justice Roberto Abad submitted proposed amendments to the rules on civil procedure. May I know which among the provisions that you may be aware of, especially those that would involve the appellate court, which you would strongly advocate for the passage of if you are nominated and appointed to the Supreme Court?
Well, I was even a participant in the Tagaytay regarding the amendments, and there were so many amendments. I now cannot recall which amendment I liked, but there were some amendments which I liked, and there were some amendments which I felt I liked, but I felt that maybe were still not right for implementation in the Philippine setting.
Was there one in particular that perhaps you feel is urgent that you would strongly advocate that you adopt so that there will be a speedy disposition of cases?
I feel that most of them could be really adopted anytime, except for the proposal that the judge would sit down in front of all the witnesses and the lawyers and try to come up with a decision or a agreement on that. That's where I find it maybe it's not yet ripe for the Philippine setting. But all the other proposals which I have come across in attending, I think, 3 meetings, I find them practically all right, and I think they can be implemented.
Thank you, Mr. Presiding
you.
Justice Reyes. That was my final question. Good luck.
Thank you po.
Thank you, Justice Lagman.
Okay. Honorable Josebi Mejia will also ask you some questions.
Thank you, Justice Lagman. Good afternoon, PJ
Good morning.
and Reyes. We've always heard about, in fact, a lot of the other candidates mentioned invariably judicial reforms. Now, for your part, PJ Reyes, what area of judicial reform do you really feel strongly about?
Well, of course, the need to change some of the provisions of the rules of court which is being done. Maybe some changes in the postponement of cases and extension of times of pleading. But for me, the most important reform that, from what I can see, is that the court would just need more budget, more funds. We need more courts. We need more court personnel. We need more buildings. I think if we just increase the number of courts in the whole Philippines, I think the bigger portion of the problem will be addressed.
The Zero Backlog Project, which again has always been mentioned, I think is synonymous or has become synonymous with your leadership as presiding justice. What is the current status of the, hearing from I think, the brain father, if I'm not mistaken, what is the current status of the Zero Backlog Project of the Court of Appeals right now?
Currently, if we talk about the age of the cases, before I came here, I looked at some data which we collected. And for our completion cases, completion of the records, we have almost like 14,000 cases court-wide, including Cebu and Cagayan de Oro, 14,000 plus. and 16% of that is more than 24 months. So only 16% are more than 24 months. And that would mean that 84% are 2 years or below from the date of filing. Now, as to those cases which were already completed and submitted for decision, court-wide, 4% are more than 2 years old. That means 96% of our cases were submitted in the last 2 years. So I think it's a good indication of we're trying still to lower it down. We would really like to go down to 1 year or 1.5 years for all our cases, and slowly, day by day, year by year, we're trying to do that.
How do you address certain opinions that high case disposition rates somehow affect the quality of ponentias?
Well, in our zero backlog project, we did not really ask people to hurry up doing their cases. It was voluntary. And then we identified justices who had a lot of cases. If Justice A would have 50 cases that are very old, what we did was we identified those 50 cases, and we determined that maybe he could let go of 30 cases, so he's left with 20. The 30 cases that will be taken from him, we will divide to justices who have no more old cases. So these, let's say there are about 10 of them. So let's say that 10 divided by 30 with 3 each. So there is no need for them to really hurry up, because most of these justices who have low loads now, because they had been there for 10 years or 8 years, 7 years, they have practically no more caseload. They can accommodate to write maybe another 30 or 40 at their own space. So there's really no timetable. Usually the zero backlog has a timetable about 6 months. And they're not given also 1,000 cases, only very few. And by computation, we would know that they could do it in the next 6 months.
Considering that the CA case management information system was made possible with the assistance of the USAID, is there a documented evaluation of this project?
There's none yet, but only this year are they going to go out with the questionnaires, and they're going to interview the justices and the law clerks and the stenographers and the other personnel to assess how it has improved the way the Court of Appeals has been doing its work in the last 4 years.
That was my final question. Good luck, PJ Reyes, and thank you, Justice Lacuna.
Thank you, sir.
Okay, PJ Reyes, good afternoon again. As I have stated earlier, we have interviewed you for several times already, and the interviews were really quite extensive. So, insofar as the questions on your application is concerned, my record shows that you have sufficiently answered all the concerns in connection thereto. How is your health now? However, I am just interested to know your condition. How is your health, Peter?
Well, I'm getting old. I'm already 64.
Yeah, is that
But
old? Okay.
I feel stronger when I was 50, but when I was 50, I felt I was weaker when I was 40. So I guess I don't know how to answer that question, but I'm all right. I had my exam 2 years ago, and
Yeah,
except for my asthma, which is once in a while, I'm all right, I think.
yeah, but because I'm reading your record and the result of your laboratory, it shows that your blood chemistry, glucose fasting is high, blood chemistry, uric acid is high, your X-ray shows suspicious faint nodule at the left lower lung field, etc. So what are you doing to address this problem?
Well, Actually, the last 2 months, I have not been really able to exercise. I've been so much, I don't know, been working hard. But usually, I try to exercise every day.
Yeah.
But the past 2 months, I've just been busy. But early this year, starting January, I refrained from eating pork and
Yeah.
have refrained from eating beef. My blood pressure before was 130 over 80. Now it's 120 over 80. So there's an improvement. Now, as to the sugar, my family does not have any diabetes history
but your
in both my father and my mother.
but your glucose is high, ah.
It's high. It can be addressed by just simply walking and walking all the time. So I just have to really walk
I
because
see.
our family has no trace of any diabetes at all from
see.
both families, my father's side and my mother's side.
But there is such thing as acquired diabetes. Di ba?
So, anyway, I promise you, ma'am, that I will now do something about. I really wanted to exercise, but it's been very hot outside. It's so hard to exercise.
Anyway, let's go to another point. My attention was called of a case decided by the Supreme Court. AM number CA1351-J. It's an administrative case which was dismissed. However, in the dispositive portion, the Court of Appeals was directed to forthwith adopt measures. This is in connection with the case filed by Merlita Pabiana. Do you remember that case?
I think so.
The Supreme Court, in its decision, states that the Court of Appeals is directed to forthwith adopt measures that will ensure the strict observance of Section 3, Rule 3 of the 2009 Internal Rules of the Court of Appeals, including the revision of the rule itself to make the consolidation of cases and proceedings concerning similar or like issues or involving the same parties or interests mandatory and not dependent on the initiative of the parties or of any of them. We just want to know what you have done to
Yes,
implement
we have.
this.
That's the case
You
I mentioned to Justice
Cayosa.
Cayosa. So we have already made it mandatory, and we are already adapting it. But when I get back to the office tomorrow, I will maybe call for more meetings with justices so that it is really observed and the more I'll give more teeth to it by Monday. But we are already doing that now.
Okay. Now, insofar as I'm concerned, I don't have any more questions. But we received questions from the Twitter, which I will ask you. No, first of all, how do you handle or deal with influence peddlers in the court?
Just decline politely. That's all. That's all. I just decline politely, and I just tell them that I'll just decide the case on the merits.
So, do you entertain follow-ups?
As the presiding justice, so many people come to me with complaints. So sometimes they complain, but they also make a follow-up. Sometimes they say, my case is pending, but then they ask for them to have. So I just tell them that you just write a letter to us if you feel the case is there for a long time so that I can write the ponente. And same time, I of course tell them that I cannot help them at all. Just write a letter on their case.
Okay. There's another question, and it's specifically addressed to you, to J. Reyes. I think you are the J. Reyes that he is referring to. The sender is a certain Eugene Alipio. We receive it only now. To J. Reyes, are you in favor of limiting the bar examinations to 4 core subjects?
Can I have the question again?
Are you in favor of limiting the bar examinations to 4 core subjects, 4 major subjects?
That's something very new. I can't answer that, but since we...
But I'm also surprised. The question is addressed to you. Maybe you know the sender. Alipio is the surname.
Well, I don't know how to answer that. That would only mean that there are only 2 days for the bar exam instead of the four weeks for Sundays. So if you limit the bar examinations to 4 subjects,
Yeah, for
the
course.
examinees will have a lot of time to really study for the 4 subjects. So most of them will really pass the bar because now they're cramped into 8 subjects. So
So,
I guess lessening it will improve the chances of everybody to pass the bar. But I feel that the subjects that are part of the bar exams, some of them are really important, and it would be hard to really compress or ignore asking the candidate about questions regarding the other subjects which will be dropped in favor of the other 4.
okay. On that note, PJ Reyes, I have no more question, and I wish you luck.
Thank you. Thank you. Can I? Thank you.
Quezon City is ready to be interviewed.
Good afternoon, Judge DAWAY. Our record shows that we interviewed you last January 21, 2013 in connection with your application for the CTA. Is it not? Yeah, okay. And during that occasion, you gave a statement about yourself. Do you want to give another statement in addition to the one you have given to us in last year?
Your Honors, the um, information about myself is in the PDS or the personal data sheet. But I would like to stress, Your Honor, that I had been a regional trial court judge for more than 25 years already, having been appointed in 1988 by the late President Cory Aquino. For the first 7 years of my stint, I was an RTC judge handling all kinds of cases or a court of general jurisdiction. Until 19 years ago, I was appointed as a special commercial court judge handling IP, corporate rehabilitation cases, insolvency, among other things. And then I had the occasion to be sent by the Supreme Court to attend several international conferences and seminars, about more than 20, Your Honors, where I attended this either as a participant or a speaker. And also I had been member of the 4 subcommittees created by the Supreme Court to draft rules of procedure, Your Honor, where the chairman of this subcommittee is a justice of the Supreme Court, and some members are also justices of the Supreme Court and also justices of the Court of Appeals, Your Honor, among other things.
Honorable Maria Milagros Fernand-Coyosa will ask you some questions.
Yes,
Judge.
ma'am.
Okay.
Thank you, Justice Lagman. Good afternoon, Judge Daway.
Good afternoon,
Yes,
ma'am.
I would like also make a statement for the record that I Judge Daway is personally known to me, and that we also have extensively interviewed him several occasions for in connection with his application for Court of Tax Appeals Associate Justice, and for the Court of Appeals as well. Now, my first question, Judge. In your personal data sheet, you stated that you have a caseload of 230 cases as of February 2014, which with an average monthly disposition of 5 cases. When one is appointed to the Supreme Court, on the average, each justice is assigned 400 to 500 cases, and they're expected to resolve at least 30 to 40 cases a year. Given these numbers, do you think you can handle the bulk of this caseload? And given that in your current court, it's a very manageable number.
I believe I can handle it, ma'am, Your Honor, because when I was a judge of a court of general jurisdiction, cases there were about 30, 40 cases a month, and I was able to have zero backlog by God's grace. Now also, with respect to my being a special commercial court judge, Your Honors, I have always strived to have zero backlog. In fact, as of April 2014, Your Honors, members of my staff are here. I am zero backlog, Your Honors. And that's the reason why I could travel abroad, because every time I make a representation for me to go to an international conference, most of the time I have zero backlog, or only 1 case or 2 cases remaining for decision within the 90-day period. If appointed, Your Honor, by God's grace to the Supreme Court as justice, I believe I will be able to find ways to be able to also tackle the work in the Supreme Court, so that I will be a deserving member of the court, Your Honor.
There are those who ask why an RTC judge would like to aspire for the Supreme Court together with the justices from the other appellate courts, such as the Court of Appeals and the Sandigan Bayan. What would convince the members of the council to nominate you over and above the other justices, you having come from the trial court?
Your Honor, I had not been amiss in applying for the appellate court. In 2014, I was shortlisted, but the then president did not appoint me. 1.5 years, I was also shortlisted in the Court of Tax Appeals, but I was not also appointed. But there was an opportunity that came to my way, Your Honors, because a few months ago, a group of lawyers, the Christian Legal Society, approached me, and they said they wanted to recommend me or not, to the Supreme Court as Supreme Court Justice. I said that has not been done before. But they said that, in their words, I have a proven track record of integrity, etc. And then finally, they were able to convince me to put my conforme on that. I know, Your Honors, that this will be really extraordinary if I get nominated, especially if I get the Supreme Court justiceship. It will be a miracle. But miracles do happen, Your Honor. And I believe that probably if you'll give a chance to me, many judges who have been serving for more than 15 years or so also, because that is what is stated in the Constitution and in the guidelines of the Council, that one should be a judge of a lower court for at least 15 years. And I had been already a judge for regional trial court judge at that for more than 25 years already, Your Honor, almost a quarter of a century. So I believe, Your Honor, this will be something which judges all over the country, regional trial court judges like me, would look forward to, Your Honors.
In your 25 years as a judge, have you found yourself in a situation where you have to support a legal position that may be contrary to your personal moral beliefs? And how did you deal with this?
I have never done that, Your Honor. I have never encountered that because I would rather do right than do wrong, even by God's grace, Your Honor. Even once I never did that in my more than 25 years in the judiciary, Your Honor.
I was referring to a situation where a legal aspect of an issue and supporting that would be contrary to your own personal and moral beliefs. If you find yourself in that kind of a situation, what do you intend to do with it?
I would follow the law, Your Honor. I will uphold my being a judge in deciding a case, Your Honor, as I have done consistently in the past.
My final question, Judge DAWAY, and I would just like to state that I'm adopting a question from Twitter. With demands of globalization in the practice of law,
Yes.
what is your vision of the Philippines steering towards that direction in light of the ASEAN adoption of globalization and liberalization of the free flow of practice of professions?
If appointed, Your Honors, I will have a position where there should be free legal services in light of globalization, but only to a limited extent at the moment, Your Honor. Like, for instance, in the field of commercial law, particularly in intellectual property law practice, corporate rehabilitation and insolvency, there can be these legal services, but probably along the lines of criminal law, there should be more strict guidelines on that because the laws of our country are different from the laws of other countries, Your Honor.
In short, you are inclined to support a limited access to legal practice in the Philippines.
Yes, Your Honor.
Okay. So as I mentioned, that was my last question. Good luck, Judge DAWAY.
Thank you very much,
Thank you.
ma'am.
Thank you, Justice Langman.
Okay. Honorable Sebi Mejia will also ask you some question.
Thank you, Justice Lagman. Good afternoon.
Good afternoon,
Judge DAWAY.
Good afternoon, Your Honor.
Good afternoon po. You sent the JBC your conforme to the Christian Legal Society's letter nominating you for the post of Supreme Court Associate Justice. In support of their nomination, they cited your professional credentials as well as your good reputation as a member of the bench. May we just know in what capacity do the members of the Christian Legal Society know you or know your personal or professional background?
I believe, Your Honor, that at least one of them practices in my court, but I have since inhibited myself from a case involving him, Your Honor. And I think they were saying that they have been looking at my record. I don't know how they came about that, Your Honor, but I would like to believe that they know that if they have cases before me, I would inhibit myself, Your Honor.
One of the papers you have written in the past, or you have presented, is entitled Training of Judges in the Philippines. Do judges receive enough training?
I believe so, Your Honor, but it was in the context of the commercial law, commercial court judges, Your Honor. This was a paper I presented at the George Washington University before U.S. judges and justices and judges all over the world, Your Honor. And it was well received, and there was even a standing ovation, Your Honor. Please, modesty aside, and by God's grace, Your Honor.
Now that you mentioned that you presented that abroad, what, if any, best practices did you learn that you wish you could adopt here to better prepare applicants to the judiciary?
I believe, Your Honor, that the best practice would be for them to have sufficient knowledge of the commercial law aspect of the cases, the court procedures on that, all the laws, of course, and then for them also to be able to attend seminars here and also abroad to make them kept abreast of international developments. In fact, I learned about the Anton Pillar Order in 2000, Your Honor, and in fact, as early as 1995, and I was one of the resource persons in the rule on civil search and seizure in trademark cases, infringement of trademark cases that was promulgated in 2002, Your Honors.
After your having passed the bar in 1978?
1978, Your Honor.
1978, you went on to take up an advanced management course. What made you choose to enroll in an non-law degree such as a management course?
I was then Assistant Vice President of the Sterling Life Group of Companies, Your Honor, and I was being acting Vice President already of that group, and then they sent me to Yale, Your Honor, for a short course, and I was in the company of top executives all over the world, and we had a good discussion on management practice at that time. In other words, Your Honor, I was thinking of a career in management at the time. But then being a UP graduate, I had to pay back. There was a time when I wanted also to serve the public because part of my education was largely financed by the taxpayers' money. So I decided to try the judiciary. In fact, the Chief Justice then was Chief Justice Fernan. He told me if I'm interested, and I applied, and by God's grace, I got the RTC judgeship in 1988, Your Honor. That was how I shifted from the corporate world to the judiciary, Your Honor.
That's my final question. Good luck, Judge DAWAY. There are some Twitter questions, but I would defer to Justice Lagman. Thank you, and good luck.
Thank you very much. Thank you very much, for Your Honor.
Good afternoon again, Judge DAWAY. Okay. Okay. So, you are the presiding judge of Branch 90 in Quezon City. Is that a special court or a court of general jurisdiction?
It is a special court since 1995, Your Honor. In fact, I was the only special court in 1995.
So what is that? What is the line? Is it a drug court or a family court or what? Commercial court?
It handles intellectual property cases,
intellectual property
corporate rehabilitation cases, insolvency cases, Your Honor.
So, considering that you have been handling that court for a long time, you can be considered, or you are comfortable with commercial laws and all those related to the cases filed with your court.
That is correct, Your Honor, and I would like to believe that I have achieved some kind of expertise in commercial law,
yeah.
Particularly in intellectual property, corporate rehabilitation, and insolvency, where I also was tasked to draft rules together with 6, 7 others po.
So how about in the other fields or areas of the law? How comfortable are you in the handling of criminal cases, involving constitutional issues, civil cases?
I will be very comfortable also in all other aspects of the law, Your Honor. If in my personal data sheet, as early as in 1991, 1994, 2007 cases, there are criminal cases that are leading cases in criminal law where the Supreme Court had upheld my decisions, Your Honor.
Good.
Let me just state, for instance,
Yes.
just the mere transporting of prohibited goods would already constitute a criminal act, Your Honor.
see.
And in the 2007 case of Valenzuela versus People, the Supreme Court upheld my position that there is no criminal offense of frustrated theft, Your Honor. And it's a leading case. It's one decided en banc by the Supreme Court, Your Honor.
Now, as you have stated, you also applied for the Court of Appeals, is it not?
Yes, Your Honor.
And also for the CTA, Court of Tax Appeals.
Yes, Your Honor.
And now you're applying for the slot in the Supreme Court. If you're given a choice, of course, I'm expecting that you will prefer the Supreme Court. Where do you want to be nominated? For example, all these 3 positions are vacant.
I would prefer the Supreme Court, Your Honor, because I have had the occasion to also have a collegial style discussion with justices of the Supreme Court and justices of the Court of Appeals in the various subcommittees
Yes.
where I was part of, Your Honor.
So
In fact, 3 of the subcommittees had already drafted the rules, and these are already promulgated. The rules on corporate rehabilitation, the rules on intellectual property cases, and also the rules on financial rehabilitation, Your Honor. Now we are working on the rules on insolvency, and I would like to believe that my contribution in this rules also had been also fairly good, Your Honors.
Judge Daway, if you're a member of the JBC, what do you think should be the best criteria in choosing a nominee for the position of Associate Justice of the Supreme Court?
If I were
A
a member of the JBC, Your Honor,
Yes.
it should be proven track record of honesty and integrity coupled with a particular field where he can also be able to contribute to the Supreme Court po. That is my honest belief, humble belief po.
Now, if you will be fortunate to be nominated and appointed as member of the highest court of the land, what do you wish to achieve as a member of the Supreme Court?
What would be?
What do you wish to achieve?
I wish to achieve a legacy where the...
What would be that legacy?
I agree with the Daang Matuwid program of the President, Your Honor.
And how can you
where
enforce?
honesty and integrity should be awarded even though they may come from the judgeship level, po, Your Honor. And I would like to have that where a simple judge can go straight forward to the Supreme Court, so he could also contribute to legal jurisprudence, Your Honor.
Yeah, as you have stated, if you will be lucky, you will be lucky that a simple judge will be appointed to the highest court of the land, what do you think will be your major challenge in the performance of your duties as a member of the court?
I would like to contribute in the development of commercial law, Your Honor, particularly in the field of intellectual property, which is one of the most important areas now of international relations and international law, corporate rehabilitation, both even in the individual rehabilitation that we have now, that we have now in our rules, and even in insolvency, Your Honor.
Okay. Now, again, if you will be a member of the highest court of the land, how do you intend to speed up the disposition of cases in the court?
I think there should be some judicial reform, Your Honor, in this line, where the Supreme Court probably can work along the lines of the Supreme Court in the United States. This is a matter of the promulgations of rules of procedure, and the Supreme Court has exclusive jurisdiction over this. Probably there should be guidelines, and only the important cases will be the ones decided by the Supreme Court, and probably like in the United States, a writ of certiorari can either be accepted or not, or issued by the Supreme Court, Your Honor, like in the U.S. Supreme Court, so that the Philippine Supreme Court can only decide on the most important cases, Your Honor. That is my humble opinion, Your Honor.
Okay. You have been the presiding judge of the Regional Trial Court for 25 years, as you have shown by the record. So you're used to be making the decisions alone, without the interference of anybody. Everything stops in your desk. In the Supreme Court, you will be working in a division with the other members of the court. Do you think you can adjust to that arrangement, where you will be working with the other justices?
By God's grace, I will be able to find a way to be able to do that job, to attain zero backlog, Your Honor. What I intend to do, if by God's grace I get the position,
Yes.
I will get good lawyers as the members of my staff. Wala pong palakasan yan. And then I will train them up to do research work so that I will be able to do my job without fear or favor, Your Honor. That is what I intend to do. And if you will give me your vote, Your Honors, by God's grace, I will be able to do my job as Supreme Court Justice, Your Honor.
Okay. My last, insofar as my personal question is concerned, this is my last. No? Now, Judge DAWAY, can you give us one strong reason for us to give you our votes?
I believe, Your Honor, that the one strong reason should be
Yes.
my track record of honesty and integrity, Your Honor, for the past 25 years, and still counting as Regional Trial Court Judge, Your Honor. That is the only humble submission I have, Your Honor, to each and every one of you.
Now, Judge DAWAY, we also received questions from the Twitter, and this is especially addressed to you by a certain Eugene Alipio. Ito, Judge DAWAY, and I quote, do you think the Supreme Court flip-flop in its recent decisions? And how do you explain flip-flopping in layman's terms? This is a Twitter question coming from the Twitter.
Can I just answer that question with what I know?
Yes.
You know, a member of the court was talking about flip-flopping before
Yes.
in one of the subcommittees that hearings that I handled. They said, I cannot be accused of flip-flopping because my position before is the same position I have, but the media says it's flip-flopping. But Actually, Your Honor, I think flip-flopping is probably a position where you change your position without any additional circumstances, Your Honor. It's like as if somebody pressured you to just change your vote, and that would be flip-flopping. But if there are other circumstances where you can also change your position, probably under exceptional circumstances, you can do that because that is provided for in the rules. In fact, a motion for reconsideration is filed, and if there are additional exceptional circumstances, probably one can change his vote. Although probably it should be avoided as much as possible because this is a matter that might also affect the integrity of the judge or the justice concerned.
Judge Daway, this is another question also addressed to you. Okay, you're very popular in the Twitter, Judge Daway. Okay, it states.
I just have a sumakit ulo ko kanina, ma'am. I took biogesic, but
Also,
it's okay.
How do you feel now?
It's
Are
okay,
you okay?
naman, ma'am.
Are you
It's
okay
okay,
na?
ma'am. It's okay. I have to
You drink
do
water.
this kasi medyo
You drink water
ang init
first.
kasi sa labas po, ma'am.
Yes. Okay.
Yes, ma'am.
Oh,
Yes,
see, this is the second question for you. Justice Abad is a strong advocate of bar reforms. Judge Daway, what bar reforms do you have in mind?
ma'am, I have already contributed a lot of my ideas in the various subcommittees. Like, for instance, in intellectual property, we have already draft decisions. We have already adopted that. I was part of those in the subcommittee that propose this. Even affidavits po, yung ganon po. These are already there in the various rules of procedure where I was also a member of in the subcommittees, Your Honor. And various other things po. Marami po tayong natutuhan sa abroad. Sa awa ng Diyos, we are trying to apply the best practices that we learn abroad to the local conditions we have here. If the other members of the subcommittee would accede to that. And this is what I've been always doing po. We cannot remain stagnant in our judiciary po. We have to adopt best practices from other legal jurisdictions which are applicable in our jurisdiction po. That is my idea on legal reforms, and we should have lots of judicial reforms. If I am if I were to be appointed with your help and by God's grace, Your Honor.
Okay. On that note, I have no further question, and I wish you luck, Judge Daway.
Thank you very
Thank you
much,
for
ma'am,
coming.
and your prayers too, ma'am. Thank you very
Okay.
much for all of
So how
you,
do you
ma'am.
feel now? Are you okay?
It's okay now, ma'am. I
can
think
bring
I'm
the
feeling
water.
better now after the interview, ma'am.
Okay. You can bring the water. You just take that.
Yes, ma'am. Yes, ma'am.
Sige. Good luck.
Thank you very much, ma'am.
Your Honors, next to be interviewed is Associate Justice Noel G. TIJAM of the Court of Appeals.
Good afternoon, Justice Tiham.
Good afternoon, Your Honors.
Yes. Our record shows that we interviewed you
2012.
2012 on October 25, 2012, also in connection with your application for Associate Justice of the Supreme Court. Okay, and you gave a brief statement then. Do you want to give another statement in addition to
Yes,
what you
yes,
have
Your
given?
Honor. Thank
Yes.
you. I just want to update the JBC that I'm still the chairman of the 7th Division. So in the seniority list, I'm number 7 in the hierarchy of 69 justices in the Court of Appeals.
Okay.
I'm a member of the Committee on Rules and also the chairman of the Committee on the CA Journal. Since my last appearance before this honorable body in 2013, I was awarded a plaque of appreciation by TO Farm because I was a member of the Board of Judges of the Outstanding Farmers of the Philippines. And then last January 2014, I was privileged to be invited by the Integrated Bar of the Philippines as the opening day speaker in the National Convention of the Board of Governors in Legazpi. So those are the updates since my last appearance.
Oh, thank you, Honorable Maria Milagros Fernan. Kayo will ask you some questions,
Thank you.
Justice.
Thank you, Justice Langman. Good afternoon, Justice
Good afternoon,
TIJAM.
Justice.
I cannot help but notice that among all the candidates, you have the longest list of recommendations from private practitioners, incumbent and retired justices, private citizens, and politicians. How did you manage all these recommendations?
It could be due to the fact that I conduct lectures nationwide, before in PhilJA and up to the present MCLE. And then I get invited by different chapters of the IBP.
Did they know beforehand that you were aspiring for the Supreme Court?
Probably they read it, Your Honor.
Yeah. How would you address concerns if these recommendations may affect your ability to decide cases independently and impartially in the future, should you be shortlisted and appointed?
I don't think my association with members of the bar will affect my independence. First of all, I have been in the judiciary for 20 years. I was RTC judge for 9 years, and this is the 11th year of my tenure in the Court of Appeals. I limit my attendance in social events. As a matter of fact, I do not attend social gatherings. I do not attend golf tournaments. I attend IBP conventions only when I'm invited as a speaker. And then I also make it a point to, if there are overtures or people who approach me about certain cases, I just politely decline them. Now, I don't think my being present and being invited by these different chapters of the IBP will affect my independence, because I think majority of them knows that I'm fair and impartial in the decisions I have made.
In good governance, transparency and accountability is required. Do you practice transparency and accountability in your office? And how do you create the balance between the need to be transparent and the need to keep confidential certain matters in the court?
I think that the element, the primordial element present in the judiciary is one of confidentiality. Now, transparency comes into the picture when we take accountability for the decisions we make. Ultimately, the public, through the media outlets, come to know about the decisions we make because they get in touch with the different information offices, not only in the Supreme Court but in the Court of Appeals. But generally, being in the judiciary, we have to be strict about the element of confidentiality.
There is, for some, they feel that there is a need to be able to standardize the application of certain doctrines emanating from the Court of Appeals decisions. What would you suggest, if appointed to the High Court, as a way to sort of come up with a uniformity in the application of certain principles and doctrines involving cases of similar situations and issues? I understand that in the Court of Appeals there is no such process.
That's correct. That's a problem that may arise from time to time, wherein a particular division in the Court of Appeals would come out with a decision which might be contradictory to another decision involving the same parties. And this is usually due to the fault of parties, litigants, who I think they resort to some form of forum shopping. They do not inform the division to where the original case has been raffled of the pendency of another case pending in another division. So probably what we have to institutionalize in the Court of Appeals is a monitoring of cases wherein similar cases involving the same parties or substantially the same parties involving the same subject matter should automatically be consolidated. I think there's already a circular from the Supreme Court addressed to the Court of Appeals that this related cases should be consolidated. But this will involve really creating a coordinating body in the Court of Appeals to see to it that the movement of cases involving the same parties or the same subject matter will be monitored. Remember, Your Honor, that there are 69 justices in the Court of Appeals. Even if I'm holding office beside another justice, I do not know exactly the number and the cases my neighbor is handling. So it's possible that there could be a related case being handled by my neighbor.
We learned that in Cebu they already practice electronic raffling of cases. Are you in favor of adopting that procedure here in Manila? Why or why not?
E-raffling, I do not know how, we have already experimented with that. I do not know how effective it was, if it is glitch-free, but I think it will expedite. It will expedite the distribution, and it will even make the distribution of cases more uniform, so that each and every justice of the court will get substantially the same number of cases assigned to them. And at the same time, it will also monitor the movements of the cases.
Okay. Moving on from the Court of Appeals to the Supreme Court, what, to your perception, is the most significant challenge facing the current Supreme Court? And if appointed to the Supreme Court, how do you plan to make a change, to make a difference in the court?
I was hoping that before Justice Abad retired, the output of his committee on the revision and civil procedure would have been approved by the court in bank, and that would have been an adequate valedictory for Justice Abad. I hope, if appointed to the Supreme Court, I would like to bring to the court a sense of urgency and tell the justices in the court that there is a need really to bring justice to the people, not only in the soonest time possible, but in a matter which is appreciated by them. I have been in the judiciary for 20 years. People win in cases, but nobody really has conducted a census whether they're happy with the decision they got, even if they win, because it's possible that the case took 10 to 15 years to decide, and they won the case, they won a sizable sum, but in the process, they realized that they spent almost 50% of what they won. So I think it is important not only to expedite the proceedings, but to see to it that certain measures are accomplished. There are many things. The Committee of Justice Abad has come out with a splendid idea. I was given a copy of the final draft. I noticed that there was a provision on judicial affidavit, which was already implemented by the Supreme Court. There was also a provision on the efficient use of paper, which was already implemented by the Supreme Court. But the main thrust of that committee was for the judge to actively participate in the conduct of the trial. But more than anything else, it also institutionalized the need of mandatory alternative dispute resolution before any trial is conducted. In other words, people are encouraged to mediate, to arbitrate, to settle their dispute before it is brought to court. Because I think the misimpression created in the public, whether it with respect to new lawyers, new judges, and even the public at large, is that if you have a dispute or controversy with somebody else, you have to go to court and undergo a trial to get relief. But we are now realizing that there are other methods that can be achieved to settle the dispute, like ADR, like strengthening the lupon, the barangay lupon, which in the first place should be the frontliner to settle dispute within the society. I'm struck by the splendid idea of a judge, as envisioned by the Committee of Justice, about taking an active inquisitorial role in the conduct of a trial by asking the parties to lay their cards on the table. This is similar to the small claims court where lawyers are not present because it is expedient and the judge is there. I have experienced this when I was in San Francisco, and I was able to observe a small claims court proceedings, and both parties right there and there were asked to state their cause of action. The other party was to state his defense and to present the respective documentary evidence and witnesses. So that's the ideal situation, wherein from the very outset the judge is confronted with an entire picture of what the case is all about, because it may not be necessary to go to trial anymore.
Thank you, Justice TIJAM. For my final question.
Yes, Your Honor.
What is your definition of moral integrity, and how will you help ensure, should you become a member of the Supreme Court, that moral integrity is upheld from the trial courts all the way up to the Supreme Court?
I think the justices and the Supreme Court should lead by example. Moral integrity is related to probity. In other words, adherence to higher ideals. It is not only a matter of honesty, but a matter of doing the right thing. I think simply by setting an example, the justices of the Supreme Court should not put themselves in a different plane from the judges of the first and second level courts and the appellate courts. They have to set an example. And I think they're doing that. They show independence. It's very important. Because by showing independence, by resisting influence or pressure from outside, the justices are able to concentrate on their work, not necessarily putting on blinders, but they're only guided by the Constitution, by the law, by the evidence, and by jurisprudence, for that matter. So it is a matter of setting an example.
Thank you, Justice Tiham. I have
You're
no further
welcome,
questions,
Your Honor.
and good luck. Thank you, Justice Lagman.
Okay. Honorable Sebi Mejia will also ask you some questions.
Thank you, Justice Lagman. Good afternoon,
Good
Justice
afternoon,
Tiang.
Your Honor.
Just a few questions, considering that we already interviewed you before and some of the questions were addressed earlier. Considering that you were a bar examiner in legal ethics in 2009, what are your thoughts on the proposal to incorporate legal ethics bar examinations questions to all bar subjects instead of just concentrating them in one particular exam?
I agree with that. I was informed by a friend who is also licensed to practice in the United States that the bar examination questions include a question on legal ethics, even in criminal law or in civil law. That's a very good proposal, and it should be adopted, because I think we train our students in law school to become competent. We train them to become adept in trial, but we do not put too much emphasis on the ethical part of it, and probably that is brought about by the fact that when a law student passes the bar exams and becomes a lawyer, he is conflicted with the thought whether the practice of law is a business, a matter of earning money, or it's a noble profession, or to do something noble or ethical. So I think we should emphasize more on the ethical requirements of the of the profession as early as in law school. And at the same time, when they join big law firms, I think it is incumbent upon their colleagues, their superiors in the big law firms, to teach them the right ethical way of practicing their profession. It is not only a question of winning the case, but winning it honorably.
I understand that you're among those who give internet bar reviews.
Just recently.
Okay, how would you
Your Honor,
evaluate the effectiveness of conducting bar reviews over the
I
internet?
really don't know how, but I think the purpose of the MCLE bar review provider was to enable bar examinees to access that internet bar review in addition to the bar review they're undergoing right now. So for example, they're taking a bar review in school, they can access that. This is something new. I think I just tried it for the last year or so.
Let me now go to the other tweeted questions.
Yes, Your Honor.
There are recently tweeted ones, but let me go to those which were tweeted earlier by Paulinette Tamaray. What are your comments, or what is your comment on Senator Legarda's proposal to have a 5-year separation time between spouses as a ground for annulment?
I'm a deeply religious person, Your Honor. Absolute divorce is not legalized in our country. Separation of spouses. I'm sorry, I did not get the question. Separation of spouses for purposes of.
Understanding is that spouses who have been separated for 5 years, the 5-year separation can now be a ground for the annulment of the marriage. That's my.
I don't think we're ready for that. I've been married for more than 40 years, and I don't think it would be good for society to adopt that kind of legislation as a ground for divorce or annulment of marriage. After all, the provision of the Constitution on the sanctity of marriage and the family as the center of the social institution itself are still sacrosanct and are still good for society.
How do you address the gender inequality which is deeply embedded in our laws?
I don't think we are now. There's a seminar adopted by the Supreme Court that is directed to be followed by all courts on gender sensitivity. And I don't think, and that has contributed a lot to creating an atmosphere of mutual respect among males and females.
That's my final question, and good luck,
Thank you.
Justice
Thank you,
Dihan.
Your Honor.
Thank you, Justice Lagman.
Now, as I have stated, we have already extensively interviewed you in the past. And coupled with the questions asked by my colleagues, I find no reason to further question you on your qualifications, which
Thank
you
you,
have
Your Honor.
already established. However, I want to ask you some questions from the Twitter, which is specifically addressed to you.
Okay.
From a certain Eugen Alipio, Justice TIJAM, do you think the mandatory continuing legal education is so commercialized?
Well, there's really a need to designate certain MCLE providers to provide that. I do not think the Supreme Court by itself has the facilities and resources to conduct MCLE training, but probably that can be remedied. That can be remedied by the participation of the IBP, for example, the Supreme Court, and the academe. Considering that lawyers are now tech savvy, they have laptops, they have tablets. I mentioned this in a forum that probably it's about time that the IBP creates a website wherein lawyers can what do you call this? And be attuned to recent decisions, jurisprudence of the Supreme Court. I have conducted MCLE lectures, Your Honor, and I'm almost always assigned at the graveyard shift, which is about from 1 to 3 o'clock. That is right after lunch, when lawyers are prone to go to sleep. So, and I noticed that some lawyers they just go through the motions of attending MCLE because it's a matter of survival for them.
Yes.
So, I think we have to make this more attractive. If lawyers in the comfort of their home, can access the training kits that will be provided by the IBP or by the Supreme Court, there might be no need for a lawyer as far as Cagayan coming to Manila, for example, to attend a 4-day MCLE seminar. But of course, there is the matter of monitoring compliance. So I was telling the audience in my MCLE seminar that probably right after you avail of the training kit, you have to undergo some kind of a examination. And if you pass that, then you are already compliant with the requirement. And but right now, I think the system is good. It is responsive. Many years ago, when I was a young lawyer, I had to travel from my office in Manila and go to UP to attend a seminar of the UP Law Center.
Yes.
But there's no more need for that because there are MCLE providers all over the Philippines.
The second question, Justice TIJAM, which is also addressed to you, is this. Justice TIJAM, what are your thoughts on mandatory legal aid service? How can you inspire lawyers to support it?
If I recall correctly, there was a circular to that effect, but I think it was sort of suspended.
Yes.
I think that should be revived but you have to give incentives to lawyers. Probably some kind of a tax break from the government in exchange for that. Because the satisfaction a lawyer gets by helping somebody who is poor, somebody who is marginalized, cannot be compensated by money. And the fact, part of the satisfaction of a lawyer is not only winning the case, but realizing that he has helped somebody. I think that is it should be made mandatory and compulsory. And even big law offices should dedicate part of their working hours to giving pro bono services. That will even probably expedite proceedings in court. I was thinking of a list of lawyers being submitted in the courtroom so that if there are litigants who do not have lawyers, there is no need to cancel or postpone the case, because the judge can appoint a counsel de officio right away, even for purposes of arraignment, or even for purposes of marking of exhibits, or even for purposes of the direct examination, without prejudice to the getting a lawyer of his choice for cross-examination, whatever it is. So it's a good program, Your Honor.
Yeah. On that note, Justice TIJAM, I have no other question, and I wish you luck.
Thank you. Thank you, Your Honors.